Yeah, all you really need to know is that the groups that were under investigation in this case spent more than $10 million getting the majority of the justices on the Supreme Court elected. And so here the Supreme Court is halting an investigation into apparent campaign finance corruption, and the groups that are under investigation spent more than $10 million to put those justices in office in the first place. There's a flagrant conflict of interest here. So I not only disagree with the way the Wisconsin Supreme Court ruled in this case, I object to the fact that they ruled at all. They had no business ruling in a case where they've got such flagrant conflict of interest.
Which brings me back to a previous segment, because anybody who takes money from anybody then is potentially corrupt. I mean, you can't govern that by the size of the donation.
Oh, you sure can, Mitch.
Size?
I don't know what the prosecutors are going to do in this case going forward.
How can
they've got... Well, just a second. They've got a really strong case before the U.S. Supreme Court that what the Wisconsin Supreme Court just did is in violation of the U.S. Constitution, and that's based on a 2009 ruling of the U.S. Supreme Court itself. In that case, the Supreme Court said that when a donor had a significant and disproportionate influence on the outcome of a judge's election, the risk of bias is serious enough to require recusal. What they said is that in cases where you're involving donors that had a significant and disproportionate influence on the outcome, they have no business ruling on cases involving those interests.
Should have taken themselves off.
Well, you take Justice Prosser's election. A total of $5 million was spent on the whole election by the candidates, by groups. Two of the groups involved in the John Doe investigation, two of the groups under investigation, accounted for almost $4 million of the $5 million in spending. That's obviously a significant and disproportionate influence.
I understand the connection, but isn't there a lot of that going around? I mean, what if WEAC or environmental group gives a lot of money to a candidate who then goes on to win? Is that corrupt? I mean,
in this 2009 case by the Supreme Court, they defined when the trigger should go off and require a judge to be disqualified. And here in this Wisconsin case, I think you've got a more flagrant example than in the West Virginia case that produced that 2009 decision.
Was that the U.S. or state Supreme Court ruling in 2009?
It was a U.S. Supreme Court ruling in 2009 in a case called Caperton versus Massey. It was a West Virginia dispute.
So you're thinking that the prosecutors should go to the Supreme Court on that question?
They've got a really strong case before the U.S. Supreme Court. In that West Virginia case, it involved a donor who put $3 million into the election of a West Virginia Supreme Court member.
Yes.
And that judge then voted to overturn a huge jury award against the company that put that money in. And the U.S. Supreme Court said, wait a second, you can't do that. You can't rule on that case when you have such a huge conflict of interest. Here in Wisconsin, we're talking $10 million that was spent electing these justices who now have ruled that this investigation of these groups should end. The prosecutors in this case have a really strong case before the U.S. Supreme Court if they choose to pursue it.
So isn't the argument it's about free speech of these groups? They want to support who they want to support, and which it comes down to the brass tacks, whether it's 10 million or 10,000. The person who's benefiting from the money then is beholden to the person who gives the money.
Well, but there's been a law. There's been a law in the books for a long time in Wisconsin that these kinds of groups can't coordinate their election activities with a candidate. And what's emerged so far,
the federal judge said that was bogus because
a lot of what's been revealed so far shows some evidence of obvious coordination. Wisconsin law says that is impermissible.
Well, they threw Wisconsin's law into the trash can on this, Mike, as you can plainly see.
But again, that's exactly what the prosecutors should be able to pursue all the way through the court system. Just because one judge ruled that way doesn't mean that that's going to be the final word. Wisconsin's law used to be enforced, and now you basically have our Supreme Court saying, we're just not going to. We're not going to allow that law to be considered anymore, and so basically they've put themselves themselves in the
No, I
position
understand
of being the
your
lawmakers
position
here.
about the money, but the law itself disproportionate, you said? Because I'm a little unclear as to when it becomes a quid pro quo, at what level of donation. And to me, that's the gray area.
What the U.S. Supreme Court said in that 2009 case was the $3 million that was put into that election by a guy named Don Blankenship to get Brent Benjamin elected to the West Virginia Supreme Court, that $3 million represented a significant and disproportionate influence on the outcome of Benjamin's election. Now, if you go back again to Justice Prosser's election, a total of $5 million in spending by both sides, both candidates, both sides groups, almost $4 million of it by just the two of the groups that are under investigation in this case. That's an even more flagrant conflict of interest than the West Virginia case that caused the U.S. Supreme Court to say that what Brent Benjamin did on the Supreme Court was a violation of due process. It was a violation of the U.S. Constitution.
All right. Where does one draw the line on when?
Well, what the U.S. Supreme Court has said is, this is the same Supreme Court that also has ruled that money equals speech and that interest groups should be able to spend unlimited amounts of money to influence our elections. But then what they've also said is that a judge doesn't have the right to rule on a case involving a group that spends a huge amount of money on their election. So that's our current U.S. Supreme Court. That's how they draw the line. Now, I obviously disagree with their ruling that money equals speech. When money equals speech, speech ceases to be free.
Well, Mike,
all the speech belongs to those who have the most money. But that's how the Supreme Court has ruled, is that these groups, in their view, can spend as much as they want, but that doesn't entitle them to have a judge sitting on a case involving them that they put in office.
Well, we'll see
that's how the U.S. Supreme Court draws the line.
We'll see if the prosecutors take this further on that point, which we don't.
I think the prosecutors, as I said, have a really strong case at the U.S. Supreme Court level that what Wisconsin's court has done
we'll see
violates the U.S. Constitution.
We'll see if they bring the case forward. We don't know that yet.